Hello. Our presentation will focus on the theme of the child's hearing, given its relevance in terms of defining parental responsibilities and in alienation cases. In this respect, we will analyze the legal regime foreseen for this subject. You can go to the next slide, please. Okay. This is a brief presentation of myself. So I'm going to continue the reading. Regarding the exercise of parental responsibilities, the regime created by law number 61/2008 of 31 October must be considered, which establishes several possibilities for this exercise. The first one, common exercise of parental responsibilities with some exceptions. B, exercise in common mitigated of parental responsibilities when the parents do not live together. And the last one, exercise of parental responsibilities by a third party. It should be noted that in 2008, the legislation changed the existing paradigm until then. If we pay attention to the Article 1006, number 5 of the Civil Code, we conclude that it has become the competence of the court to determine the fate of the children, considering their superior interest. As Luana Salazar Gomes points out, contrary to what had happened till then, the court on this issue ceased to play a subsidiary role in relation to the agreement of the parents, making this one of many elements to which the judge must pay attention in the decision-making process. The only issue whose regulation continued to be accorded primarily to parents was the maintenance owed to the children and how to provide it. We can go to the other slide, please. As a principle, Articles 1001, 1006, number 1, 1011 and 1012 establish the joint exercise by both parents, whether we are dealing with issues of particular importance or not. If there is a lack of agreement by one of the parents on matters of particular importance, one of the parents may appeal to the court with a view of conciliation under the terms of Article 44 of the regime that we have in Portugal about the protection of the child. If this is not possible, the court will hear the child before the decision in light of the Article 1001, number 3. One joint exercise by both parents, and you can go to the next slide, please, will not occur in, and the other one, please, will not occur in situations. Now you can see the legislation that I'm speaking about. One joint exercise by both parents will not occur in situations of impediment and death of one of the spouses, in a situation of inconstituted filiation as regards one of the parents, or when the parents do not reside together and the exercise in common is considered contrary to the interests of the child. You can go to the other slide, please. It appears now we have here the legislation that I'm speaking, and how in Portugal we define the general regime of civil guardianship procedures, Article 5, and I have put here some sentences that are important and that clarify how do we work in Portugal. It appears, therefore, that family law turns out to be increasingly focused on the child, and it is important to clarify the meaning of the best interest of the child, which has become the object of the judge's free appreciation. Several authors have focused on the implementation of this expression, has happened with Maria Clara Sotomayor, who mentions in this regard, this criterion only occurs practical effectiveness when referring to the interest of its child, as there are as many interests of the child as there are children. You can go to the next slide, please. Here we have an image that can clarify how in Portugal we can hear some classes that we can hear the children. Law 1041 2015 of 8 September, which approved the general regime of civil guardianship procedure that I have spoken before, and make the first amendment of law 1003 2009, which establishes the legal regime of civil sponsorship, establishes principles to be observed in the process applicable to civil protective measures and respective incidents. In Article 3 of this law, and you can go to the other slide, please, we find, and you have here some rules that we have to focus in Portugal. In Article 3 of this law, we find the tutelary measures to which this regime is applicable, namely the regulation of the exercise of parental responsibilities and knowledge of issues relating. Article 4 of the diploma defines the principles applicable to the civil tutelary processes regulated in this regime, with emphasis to the following. First, instructional simplification and orality. Second, consensus. Third, hearing and participation of the child. Article 5 highlights the principles applicable to the hearing of the child, with many of the principles already resulting from the provisions of the Convention on the Rights of the Child adopted by the General Assembly of the United Nations on November 20. And Portugal have ratified this convention in 2019. We highlight in this regard, and you can go to the next slide, please. We highlight in this regard the provisions of paragraph 3 of the regulation, which states that, and I'm now reading the law, the hearing of the child is preceded by the provision of clear information on the meaning and scope of the same. Paragraph 4 safeguards, namely, the specific conditions in which this hearing must take place. First, the child is not subject to an intimidating, hostile, and inappropriate space or environment for his, her age, maturity, and personal characteristics. And second, the intervention of judicial operators with adequate training. Once again, this will be one of the areas in which the contributions made by other areas like psychology and are especially relevant. It should also be noted, and you can go to the next slide, please. It should also be noted, now we have here the civil code, the civil code that they have all the regime about that we are talking about. You can go to the next slide, please. Okay, now we have here some rules how the court must hear the child. It should also be noted that the agreement of sentence regulating parental responsibilities can be changed, which can occur by mutual consent of the parents, and this agreement must be subject to approval by the Public Prosecution Service or judicial approval. We cannot ignore that in terms of changing the regulation of the exercise of parental responsibilities, uses related to the parental alienation syndrome have assumed great importance in recent years, and there is in fact jurisprudence to support this position. You can go to the next one, please. Okay, now we have the continuation of the rules and how in Portugal the judge can decide when he's judging about the exercise of parental responsibilities. When we refer to situations of parental alienation in terms of parental responsibilities, we know that often children do not manifest when heard this alienation, but they demonstrate by their behavior whether at school or in other places of interaction, that something is not right. It is very important that teachers at school and family members who are closest to the child realize that it is essential to detect signs that the child's will is compromised. With this expression, we intend to draw attention to the need to make the child see that it's okay to find himself many times divided in his opinion and in what he wants for his new life once the separation of the parents has occurred. The difficulty of correctly typifying parental alienation and applying the law to the concrete case most of the time stems from the lack of specific knowledge of his syndrome. Can you go to the next slide, please? Judges, lawyers, psychologists, and social workers lack specific scientific knowledge. It is common to add to the records evidence of parental alienation without a proper analysis of it, and unfortunately, situations of injustice are generated by regarding the alienating parent as he has achieved his intention, that is, to destroy the other parent with the protection of inadequate expertise. You can go again. Among the most common, okay, now you have exactly that what I was saying just right now. Among the most common alienating behaviors are some, and I'm going to give some examples. You can go to the next slide, please. Now you have an image of the court in Portugal, the relation that many times has to take place in these matters. You can go to the another one, please. Yes, now I'm going to give some examples of alienating behaviors. You have limit or exclude the child's contact with the alienated parent and his or her family, cultivating the child's dependence on the alienating parent, and 3, making important decisions about the children's life without prior consultation with the other parent. And about that, we have some decisions about extracurricular activities, choice and or omissions on mental health, technicians to assist the child, choice or change of school. How can we identify the signs and promote a culture of combating parental alienation in the courts? You can go to the next slide, please. Yes. Alienating behavior that deny the child his need for security and comfort, representing, therefore, an evil and negative parenting, which can to disrupt the family relationships and cause ruptures in the child's relationship with one of its parents and other family members, representing, therefore, a disrespect for the freedom of affections and for the family institution, for the stability and maintenance of family ties, reference points of the child, his best interests, and his fundamental rights. So you can go to the other one, please. We have here what it should be, not what, unfortunately, many times is not like that. In fact, and you can go to the other one, please. Okay. In fact, constitutionally entrusted with the duty of administering justice, it is up to the courts that are responsible for settling conflicts generated around the exercise of parental responsibilities, always in pursuit of the best interest of the child, but stability and security of family relationship. Now, the specificities of the jurisdiction of the family and children requires the creation of courts with special features as well. That and experience has in fact shown that in cases that we have spoke, in which the regulation of parental responsibilities occurs in context of authentic dysregulation of feelings and affections more than a legal answer, dictated in the dryness and objectivity of a sentence, users of justice need authentic therapeutic work, which does not dispense with resort to specialized technical advice, within an interdisciplinary framework and to a dialogue that is very, very important, and it must be, this dialogue must take place in hospitals, in schools, in kindergartens, in all that place. You can go to the other one, please. Okay. This step was taken with the entry in force of Law 62/2030 and with the decree law that 41/2040. Diplomas that lead to the installation of specialized jurisdiction in the area of family and children, whose competence now covers almost the entire national territory. Thus, taking advantage of these specialized structures and the technical assistance available to them, the family and juvenile courts are today in a position to give a more adequate response to the problematic of parental alienation, which necessarily passing through the evaluation of all the intervenants, parents and children, in the sense of losing the cause of the affective and family distancing that is intended to be overcome, and the presence of possible manipulation of the will of the child and of young person that can be achieved through monitoring. And you can go to the other slide, please. It's the last one. Specialized care of parents and children during the implementation of a regime of regulating provisionally defined as parental responsibility. So, finally, the response of the family and juvenile courts to this problem can still be implementing during the implementation of the regime of regulation, the liberties, parental rights established, whenever this is a risk of non-compliance, namely with the regime of living together that we have spoken about. Thank you for listening, and I hope you have a nice conference. Thank you.